We found that at least 60 people around the world have been euthanized or assisted in suicide. That includes in 3 jurisdictions in the United States, Colorado, California, and Oregon, where assisted death is legally restricted to terminal conditions. So we saw anorexia nervosa listed by name as a terminal condition. In 2 of the states, we could not find any mention of documented cases in the annual state reports. 100% of the cases we reviewed were women. A third were between the ages of 18 and 30. They had decades of life ahead of them.
I'm very clear who this bill is aimed to help and who it is not aimed to involve. It also says, for the avoidance of doubt, this cannot be a mental disorder or a disability.
Eating disorders are classified as mental disorders under the Mental Health Act, and this bill explicitly states a person cannot be considered terminally ill only because of a mental disorder.
Mental disorders, especially eating disorders, not just anorexia, impact the body, and they have life-threatening consequences. We had 20,000 acute hospitalizations for eating disorders in this country last year, and we have, again, massive gaps in care. And
it indicates that in Oregon, California and Colorado, patients with anorexia have qualified as having a terminal illness. And there have been instances where patients suffering with anorexia have been described as terminal and treatment withdrawn in the UK itself. Is it accurate in your view to regard these young women as suffering with a terminal illness?
No, I do not think it's accurate. There are clinicians, a very small minority, who disagree and have characterized anorexia by name as a terminal illness, but they have also said that eating disorders qualify.
The definition of terminal illness is very clear. The person not to be considered to be terminally ill by reason of having one or both either a mental disorder or a disability. So I think that would cover that case.
I think you've left out an operative word in that sentence, which is only.
Regarding eating disorders and other disorders, obviously we've heard one version of that. In terms of your experience of working with UK law to the highest level, what your assessment of that is?
Yeah. I mean, I have worked in a range of medical treatment cases over many years, so different illnesses and conditions, and Section 2 to me reads fine. It works. It's clear. From anorexia, I mean, I don't consider it to be coming into a terminal illness unless it's right at the end of life, and that doesn't really fit within the parameters of this Act.
I would refer to a 2012 Court of Protection case where a 29-year-old with anorexia was described as in the terminal stage of her illness, where the physicians, multiple physicians, described her death as inevitable. 2023 case where a young woman, she was described at pre-death stage. That young woman, again, is still alive. We have case law in the UK where people with anorexia are being found to be terminal.
I don't think they were found to be terminal, but they were described by a doctor in a case that they were terminal, and that doctor may not have described it properly.
Indeed, but a judge will be relying on
Thank you. So all around Australia, mental health is, as the primary terminal illness, is excluded. So anorexia by definition is excluded. I have had a patient come to me with anorexia as their terminal illness requesting voluntary assisted dying, and it is a relatively easy assessment because they do not meet the standard criteria, and I was able to explain to them that they were not eligible.
Across Australia, having a disability or having a complex mental health issue like anorexia did not make you eligible at all for voluntary assisted dying. The legislation you were dealing with is not for people with a disability, it's not for people with anorexia nervosa, it's not with people who have a burden.
Now, there are people who feel that they are a burden. People can feel that they are a burden, and they are actually, that is part of their autonomous thinking. People have their own views of their own life. And
the law that you're proposing to legislate in the UK is this similar to the laws that exist in Australia, New Zealand and most of the laws in the United States, that they only apply to people who are terminally ill, and therefore people who only have a primary disability, a primary mental health condition, a primary dementing condition or a non-terminal condition such as anorexia or a whole host of other conditions that are found eligible in the more permissive laws simply wouldn't actually be able to be found eligible.
On the issue of anorexia, I do think this is slightly, the numbers are just really tiny. So in the Oregon model, which is what's in this bill, you're talking 1 or 2 people in the history of assisted dying. It's like a very sort of minor kind of issue to get focused on. I've seen so much about this in the press and discussed here, and this is really not what we're actually. I mean, if you're very concerned about terminal anorexia, I'm sure that there's some tinkering you can do with the bills. In jurisdictions that have legalized the Oregon model, which is what this is, there is 1 or 2 cases. I mean, this is not something that should be given a huge amount of time, because it's a distraction from the fact that really what we're talking about is a new mode of dying. To get fixated on the 2 people with terminal anorexia who have access to assisted dying in the States is a bit of a red herring.